Lots of folks in North Carolina are talking about criminal code recodification. I'm Jessie Smith, and in this presentation, I'll explain what that's all about. It's been said that there's something missing in North Carolina law. Specifically, that North Carolina lacks a streamlined, comprehensive, orderly, and principled criminal code. A criminal code is a set of laws that says what's a crime. It covers things like murder offenses and assault crimes. In North Carolina, however, it's argued that we lack a streamlined, comprehensive, orderly, and principled criminal code. What makes folks say that, and why does it matter? Well, although many of the state's crimes are codified in Chapter 14 of the General Statutes, entitled Criminal Law, criminal offenses actually are peppered throughout North Carolina's general statutes. Felony offenses are found in 53 separate chapters of the general statutes. Misdemeanors are spread throughout 142 chapters of the general statutes. Additionally, the law gives administrative bodies and boards the authority to create crimes. For example, provisions in the general statutes make it a misdemeanor to violate any regulation promulgated by the Board of Dental Examiners. Thus, a dentist who runs an ad but neglects to include a statement regarding whether he or she is a general dentist or a specialist is a criminal. Also, North Carolina counties, cities, towns, and metropolitan sewerage districts also have the authority to create crimes through local ordinances. Thus, because a local ordinance of one small town makes it unlawful for a person to allow chickens or other domestic fowl to be at large in the town, that means that such conduct is a misdemeanor, a crime, in that jurisdiction. Given that no central statewide database exists collecting all crimes created by administrative bodies, boards, and local government units, it is impossible to state how many crimes exist at any given time in North Carolina. Also, this approach to creating crimes makes it difficult for law enforcement officers, prosecutors, defenders, and judges to know and understand the law. It also undermines a critical purpose of a criminal code, providing notice to citizens of what conduct is prohibited. A comprehensive code would clean all of this up by logically organizing all of the state's major offenses within one chapter of the general statutes. In addition to failing to include all of the state's major criminal offenses in a single chapter, many core principles of criminal law and liability are not even addressed in the statutes. Put another way, there are a lot of missing pieces. For example, North Carolina continues to recognize a number of common law offenses that, except with respect to sentencing, have never been codified. Some of the state's common law offenses include things like robbery, arson, and manslaughter. None of them are in the criminal code. Additionally, North Carolina recognizes common law principles of criminal liability, like aiding and abetting. None of them are in the code either. North Carolina law also recognizes general crimes like conspiracy and attempt. Again, not defined by the code. Ditto for criminal defenses, like necessity and duress. There are more missing pieces. For some crimes, no mental state is specified, or if it is, it's not defined. Nor does the code define many other key terms. For example, no statutory definitions are provided for key terms in the state's assault statutes, terms like serious injury and deadly weapon. All of these missing pieces create problems for North Carolina. Among other things, it creates ambiguity and uncertainty that fuels litigation and increased costs to the court system. And the failure to define critical terms and concepts in the code may lead to liability where none is deserved or allow guilty offenders to escape conviction. Again, a comprehensive criminal code would clean up these problems by defining all core ideas and terms in simple, easily understood language. As we've seen, the code is missing core provisions. At the same time, it is unnecessarily complex. Adding to its complexity is the fact that the same conduct is prescribed by multiple provisions when one would suffice. For example, although North Carolina law recognizes a general crime of larceny, there are separate statutory provisions for, among other things, theft of dairy milk cases, larceny of motor fuel, larceny from a construction site, larceny of secret technical processes, larceny of public records, larceny of wills, larceny of ungathered crops, larceny of ginseng, larceny of pine needles and straw, larceny of portable toilets, and stealing political signs. A streamlined code would collapse these offenses into a single crime with separate punishment levels if needed, thereby reducing complexity and associated costs. Put another way, it would clean all of this up, leaving us with all we really need, one general crime of larceny that applies to all of these situations. The proliferation of new offenses that have been engrafted in an ad hoc manner onto the existing code causes other problems. As new offenses have proliferated, so has overlap among them. In some cases, a single act can result in multiple overlapping charges and convictions, all with different elements, required proof, and creating unnecessary complexity and associated costs. For example, passing a worthless check of $500 can result in a charge of worthless checks, a Class 3 misdemeanor for checks under $2,000, and for obtaining property by false pretenses, a Class H felony for amounts under $100,000. If the most serious offense were properly punished, there would be no need for this type of overlap and the complexity it creates. Additionally, because the prosecutor has discretion with respect to charging, overlapping offenses create potential for widely disparate results that may be perceived as arbitrary and unfair. An orderly, principled code would reduce overlap among crimes and provide clear rules for when multiple punishment is prohibited or permissible. Still, other problems have been noted with our existing code. In some instances, the law is inconsistent. For example, one statute says that a person tried for obtaining property by false pretenses can't later be prosecuted for larceny or embezzlement based on the same facts. But the reverse isn't true. The statute doesn't bar the state from charging a defendant with obtaining property by false pretenses after a trial for larceny or embezzlement. The code also includes provisions that are clearly unconstitutional and invite error, wasted resources, and the violation of rights. For example, one statute provides that a defendant convicted of a certain sex offense may be sentenced to an elevated term if the judge finds egregious aggravation. However, this procedure runs afoul of the United States Supreme Court's decision in Blakely v. Washington, as the North Carolina courts recognized in a case where a trial judge unwittingly followed the unconstitutional statutory mandate. Other criminal statutes are outdated and not in line with what citizens would expect to be criminal. For example, one statute entitled Fornication and Adultery makes it a crime for a man and a woman who are not married to each other to live together as if they are husband and wife engaging in habitual sexual intercourse. All of that can be cleaned up as well. How? By addressing this, our lack of a streamlined, comprehensive, orderly, and principled criminal code. Rewriting the state's criminal laws to produce such a code can address this. As we've seen, the lack of one creates costly inefficiencies, opportunities for unfairness, and undermines the effectiveness of the criminal law. This comprehensive rewriting of the code is referred to as recodification. It's a process that's designed to create a streamlined, comprehensive, orderly, and principled code. The primary goals of recodification are to rewrite the criminal code to include necessary provisions not in the current code, such as mental states, defenses, and definitions of offenses and key terminology. Second, to eliminate unnecessary, inconsistent, or unlawful provisions in the current code. Third, to revise existing language and structure to make the law easier to understand and apply. And fourth, ensure that criminal offenses and legal rules are cohesive and relate to one another in a consistent and rational manner. And fifth, at the same time, seek to preserve the General Assembly's substantive policy judgments as reflected in the existing code, as well as the legal principles established in the case law. So how can recodification be done? There are lots of options. One is using a recodification study commission that is broadly composed of all justice system stakeholders. It would produce for the General Assembly a new, streamlined, comprehensive, orderly, and principled criminal code. To learn more about recodification in North Carolina, click on the link below for a short briefing paper.